Hello students, welcome to Muslim Law Lecture. I'm Marjina Sultana, an Assistant Professor from Interpersonal Law College, Greater Noida. Today we will study will under Muslim law. The term will is equivalent to Arabic word wasiyat. In Islamic law, a will executed by a Muslim is known as wasiyat, and a document which embodies the will is called wasiyatnama. Tayyibji defines will as a conferment of right of property in a specific thing or in a profit or advantage or in gratuity to take effect on the death of the testator. So a will is a legal declaration of transfer of property or the distribution of property by a person after his death. So there is two elements. The first one is the distribution of the property. And the second element, which is the most important characteristics of a will, that is, the will is to take effect after the death of the maker of the will, that is the testator. A will, in Islam, a will is a divine institution since its exercise is regulated by the Quran. And Amir Ali also defined will as it's a divine institution because it is regulated by the Quran. The person who executes the will is called legator or testator, and the person in whose favor the will is made is known as legatee. Now let's discuss what are the essentials of a valid will. First, the legator must be competent to make a will. Second, the legatee must be capable of taking such endowment, or we can say he must be competent to take the legacy or bequest. The subject of the bequest must be a valid one, and the fourth condition or essential is that the bequest must be within the limits imposed on the testamentary power of a Muslim. So the first essential, that is the in relation to the competence of the testator. So what is meant by competent? The legator is competent if he is adult and is of sound mind. So every adult of sound mind can make a will. So we can ask the question of the majority of the legator. It can be understood from two angles. The first, according to the Muslim law, a person is attained the majority at the age of 15. But according to the Indian Majority Act, a person, a minority, is terminated at the age of 18. So he becomes a major at the age of 18. But in the case of those whose guardian has been appointed by the court, the minority terminates at the age of 21. So according to the Muslim law, a person it becomes a major. He's not a minor if he is attained the age of 15. He reached majority at age of 15, and according to the Indian Majority Act, if the person has attained 18 years, he is a major. But if his or her guardian is appointed by the court, then he becomes he reaches majority at the age of 21. So such person can make a will. They are competent to make a will. The second condition, that is the legatee must be competent. It means that a person who is capable of holding a property may be the legatee under a will. So, uh, anyone cannot be made a beneficial owner against his or her will. So, the express or implied assent of the legatee after the death of the testator is necessary, it is required. So, assent is to be made after the death of the testator. Similarly, in the case of legator also, we cannot the bequest, a will, cannot be procured by undue influence, coercion, or fraud. So, if any will is procured or received by use of undue influence, coercion, or fraud, it is not a valid will. And if the legatee has not assented to the will, then it is also not a valid one. Some of the example, that is to whom a will can be made is any person who can hold the property, and the bequest can also be made to an institution, to a non-Muslim, even to an unborn child if the child is born within 6 months of making the will. So these bequest to an institution is a valid one. Bequest to a non-Muslim is also a valid one. There's a, according to the verses of the Quran, you are not prohibited, O believers, from acts of benevolence towards those who subject themselves to you and refrain from battles and contention. So it is clear that a Muslim can give his property by bequesting the same in favor of a non-Muslim, provided the non-Muslim is not hostile towards Islam. Okay, so there's no bar to making a bequest or making a will in favor of the non-Muslim. And will can also be made, as I have just we have just discussed, that in can be made to in favor of unborn person, if such child is born within 6 months of the date of making the will, because such child is treated as a legatee in existence. But under Shia law, a bequest to a child in the womb is also valid if it is born in the longest period of gestation, that is 10 lunar months. If a child is born within 10 months, it is valid under Shia law. Okay, so bequest for a charitable object is also a valid one. The third essentials of a valid will, that the subject of the will and its validity, it is related to the validity of the subject of will. So what are the requirements? The property which is to be bequeathed must be a transferable one. It must be capable of being transferred, and this property must be in existence at the time of the testator's death. It is not necessary to be, the property need not be in existence at the time of the making of the will, but it must be in existence at the time of the uh, death of the testator. And the third, and also that the testator must be the owner of the property to be disposed of by will. So the subject of the will, that is it must be a transferable one. It must be in existence at the time of the death of the testators, and it must the testator must be the owner of that subject of that property that is to be disposed by the will. And the fourth essentials is the testamentary power and its limits. It is the exercise of the testamentary power, of the power of making will, is limited under Muslim law. There are twofold restrictions. One, on the power of the Muslim to dispose of his property by will. So, what are the restrictions? The restrictions are twofold. One is the limitation as regards the person in whose favor the bequest is made, and the second limitation is in relation to the property, that is, the extent to which the testator can dispose of his property. So, the first limitation as regards the person is that the rule the rule is very clear. The bequest in favor of heir is not valid. Under Islamic law, the bequest of the making of will in favor of heir is not valid unless the other heirs consent to the bequest after the death of the testator. Why? The purpose, this the making of the will is to to be it is meant to make in favor of those who are excluded by the succession. Okay, so these enable, and this we can say this will enables the testator to make maintenance of those relatives who are excluded by the law of succession or inheritance. So, as the heirs are the legal, they have the right to inherit the property. They cannot the will cannot be made in favor of the legal heir. Okay, so if any will is made in favor of an heir, it must be the other heir must have consented after the death of the testator. And another limits on the bequest on the testamentary power of the Muslim is to the extent of property. How much property can be bequeathed by will. So no Muslim can make a bequest of more than one third of his net assets, of his entire asset, after payment of funeral charges and the death. So after the death of a Muslim, the first thing to be done is to make the payment of funeral charges. And if the testator was in debt or he owes money to anyone, to someone, then the debt or money that is owed must be paid off. This should be the debt and the funeral charges, and the payment of the funeral charges and the debt must be made. After that, his property must be distributed among his heirs. And if he made a will, then other than though made a will in favor of anyone other than his heirs, then it must be realized. But there is a limitation, the limitation that it cannot exceed one third of his entire asset. Okay, so why this limitation is not to deprive the lawful heirs, the legal heirs, from their lawful claims. It is to protect the rights of the heirs. So this was all about the will, and that's it. Thank you for watching.